Don't forget to subscribe to our channel for more videos, and press the bell icon to receive updates.
The adjudication of a court of law is divided into two classes, decree and orders. In this particular session, we are going to discuss decree. A decree is an official order that is drafted and issued by someone in a position of legal authority, like judge. Section 2, subsection 2 of the Code of Civil Procedure 1908 defines decree as follows. Yesterday also we have seen the definition. Decree means the formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the rights of the parties with regard to all or any other matter, any of the matters in controversy in the suit, and may be either preliminary or final. It shall be deemed to include the rejection of the plaint and the determination of any question within section 144 of CPC, but shall not include a any adjudication from which the appeal lies as an appeal from an order, or b any order of the dismissal for default. Explanation: a decree is preliminary when further proceedings have to be taken before the suit can be completely disposed of. It is final when such adjudication completely disposes of the suit. It may be partly preliminary and partly final. So today we are going to analyze this particular definition in detail. In Vidyacharan Shukla versus Khupchand Baghel, AR 1964 SC 1099 case, the Supreme Court held that the order that a decision of a court to be a decree, the following elements must be present. There must be an adjudication. Such adjudication must have been given in a suit. It must have determined the rights of the parties with regard to all or any of the matters in dispute in the suit. Such determination must be of conclusive nature, and there must be a formal express. Now, in consecutive slides, we are going to study each and every point of this particular characteristics in detail. In Balkishore versus Tulsibai, AR 1987, MP held that order must satisfy the requirement of section 2, subsection 2, in order to become decree. Merely labeling it as a decree does not make it a decree. Now we are going to study this particular characteristics. The 5 characteristics given by court in the Vidyacharan Shukla versus Khupchand Baghel in detail. First essential element of the decree is adjudication. There should be adjudication. Adjudication is the first essential of decision of the court to be a decree. The matter in dispute should be judicially determined. ये word आपको ध्यान रखना, judicially determined. It should be this particular order is given by judge. In Madan Naik versus Hansubala Devi, AR 1983 ST 676 case, the court held that if the matter is not judicially determined, then it is not a decree. In Dipchand versus Land Acquisition Officer, AR 1994 SC 1901 1903 page case, the court held that the adjudication should be made by the officer of the court. And if it is not passed by an officer of the court, then it is a decree. In Motilal versus Padma Ben, AR 1982 Gujarat 254 case, the court held that a decision on matter of an administrative nature or order dismissing a suit for default of appearance of parties of dismissing an appeal for want of prosecution cannot be termed as a decree, in as much as it does not judicially deal with the matter of the dispute. मतलब जो ऑर्डर निकला है वो एडजुडिकेटेड होना चाहिए, जज के थ्रू आना चाहिए या जज ऑफिसर ऑफ द कोर्ट की तरफ से आना चाहिए. अगर वैसा नहीं है तो then it will not be called as a decree. Second essential element was given as a suit. A requirement of a suit is the second essential decision of the court to be decree. Without suit, there cannot be a decree. Suit ordinarily means a civil proceeding instituted by the presentation of a plaint. Civil suit is the institution of litigation for enforcement of civil rights or substantive right. It may be against state or individual. A suit is resulted into decree. In Meenakshi versus Subramanya, 1888 ILR 11 Madras 26 page 35 case, the court held that when there is no civil suit, there is no decree. तो फर्स्ट एलिमेंट हमने देखा ना, एडजुडिकेशन चाहिए, जज के थ्रू चाहिए ऑर्डर, ओके, या ऑफिसर ऑफ कोर्ट की तरफ से चाहिए. सेकंड एलिमेंट हमने देखा ये सूट में है. अभी हम लोग सूट की बात करते हैं तो सूट के एसेंशियल्स भी सेटिस्फाई होने चाहिए. तो सूट के एसेंशियल्स क्या है? तो सबसे पहले है कि अपलेंट होना चाहिए. ये तो पहले ही अभी के मीनाक्षी वर्सेस सुब्रमण्यम केस में, सॉरी जगदीश्वर सहाय वर्सेस सुरजन सिंह केस में बताया कि अपलेंट चाहिए. सेकंड, there should name of the parties, or there should be two parties. To constitute a suit, there must be at least two opposing parties, the plaintiff and the defendant. There is no limitation with regards to number of either side, but there should be two parties. Okay. Second, there should be a cause of action. A cause of action means the whole of the material facts which is necessary for the plaintiff to allege and prove in order to succeed. The cause of action is essential to suit, represented in order 11, rule 2 of the code, wherein it is stated that a plaintiff must mention the cause of action. Every plaintiff must disclose a cause of action. If not, Order 7, Rule 11 of the code states that it is the duty of the court to reject the plaint. Example of cause of action are breach of contract, fraud, defamation, etc. So सूट में जो second point जो पहले तो plaint होनी चाहिए, second में parties होनी चाहिए और cause of action होना चाहिए. अगर cause of action नहीं है plaint में तो वो suit reject हो सकती है और court को power है. Then there should be a subject matter. There must be a subject matter with respect to the civil dispute exists. A subject matter of the suit is the particular thing in the respect of which the suit has been filed. The process of proving and disapproving in proceedings can be done on basis of certain facts. These facts, which essentially go on to prove or disprove the cause of action, will be called the matter in the issue. It can either be some property upon which the plaintiff exercises his legal right, or it can be personal right of the plaintiff not related to any property. There cannot be practically anything other than these things for a subject of matter of the suit. मतलब generally अगर हम देखेंगे तो maximum cases आपने देखें तो property के right है या individual right है, ये type के ये है. Then relief claim by the plaintiff, that is the next essential of the suit. No court will be give relief unless relief is specifically claimed by the party. Relief is of two types: specific relief and alternative relief. Now there are certain enactments with specific provisions. Under certain enactments, specific provisions have been made to treat application as a suit. मतलब अगर इनमें अगर कोई भी केस आता है, होता है, प्रोसीडिंग्स होता है, तो उसको हम लोग क्या बोलेंगे, सूट बोलेंगे. जैसे कि इंडियन सक्सेशन एक्ट, द हिंदू मैरिज एक्ट, the Land Acquisition Act, the Arbitration Act. In Lila Hotels Limited versus Housing and Urban Development Corporation Limited, AR 2012 SC 903 case, where the question was whether the award of an arbitrator tantamounts to a decree or not. The court held that Section 36 of the Arbitration and Conciliation Act 1996 makes it very clear that such an award has to be enforced under CPC in the same manner as if it were a decree of the court. Accordingly, it was held that the said language leaves no room for the doubts as to a manner in which the award is to be accepted. मतलब एक्ट में ही अगर प्रोविजन दिया है कि जो ऑर्डर है उसको डिक्री के तरह का ट्रीट करना है, तो that cannot be challenged. In Diwan Brothers versus Central Bank of India, AR 1976 SC 1503, page number 1518 case, court observed that the decision of tribunal, even though described as a decree under the act, is a decree passed by the tribunal and not by a court covered by section 2 subsection 2 of the code of the civil procedure. That's why it is not a decree. Now we'll come to the third essential element of the decree, that is the rights of parties. An order to be decreed must have determined the rights of the parties with regard to all or any of the matters in controversy in the suit. ये definition भी हमने देखा है. It is मतलब जो right determine होता है वो for all or any part matter, any of the matter in controversy in the suit. The expression matter in controversy in the suit means such a matter as has been brought up to adjudication by the court through the pleadings. प्लेन दाखिल किया गया है और उसमें जो प्लीडिंग्स हो गए उसमें क्लियर मेंशन किया कि ये मैटर के ऊपर हमको एजुडिकेशन करना है. Hence the conclusive determination in order to amount to be decree must be on matters in controversy. जो लास्ट में हम एक essential देखे conclusive determination, तो किसका conclusive determination होना चाहिए, तो ये rights of parties का. For example, an order rejecting the application of a poor plaintiff to waive the court cost is not a decree because it does not determine the right of the party in regards to the matter alleged in the suit. In Dattatreya versus Radhabai, AR 1921 Bombay 220 case, the court observed that the word right means substantive rights and not merely procedural rights. In Kanji Hirjibai versus Jivraj Dharamshi, AR 1976, Gujarat 152 case, the court held that the term parties means parties to the suit, that is the plaintiff and defendants. And if an order is passed upon the application made by the third party who is a stranger to the suit, then it is not a decree. Decree तभी होगी ये दो parties के बीच में से adjudication से होगी. In Ahmad Musaji Saleji versus Hashim Ibrahim Saleji, AR 1915 PC 116, the Privy Council held that the expression matter in controversy refers to the subject matter of the suit with reference to which some relief is sought. मतलब जो हम लोग इसमें जो बात करें मैटर इन कंट्रोवर्सी की, तो मैटर इन कंट्रोवर्सी जो होगा वो सब्जेक्ट मैटर ही होगा जो सूट का है. इन माचोन वर्सेस AR 1927 Rangoon 148 PC case, the Privy Council held that there must have been an adjudication on the rights of the parties. And in Guwahati Bank Limited versus Baliram, AR 1950 Assam 169 case, the court held that an order of dismissal for default of appearance is no determination of right of the parties and therefore no decree. मतलब अगर कोई ऑर्डर निकला है और पर्सन वो डिफॉल्ट कर रहा है अपीयरेंस में, तो उसके खिलाफ जो ऑर्डर निकलेगी उसको डिक्री नहीं बोलेगी. The fourth essential element is decree is conclusive determination. Such determination by the court must be conclusive in nature. This means that the court will not entertain any argument to change the decision, that is, as far as the court is concerned. The matter in issue stands resolved. Thus, any interlocutory order not deciding of the parties is not a decree. मतलब जो ऑर्डर निकलेगी that should give conclusive determination. कोर्ट के हिसाब से अगर एक बार फाइनल conclusive determination हो गया, फाइनल डिग्री निकल गई, इसका मतलब है that particular suit is disposed of. Okay. In Narayana Chandra versus Pratirod Sahini, AR 1991, Calcutta 53 case, the court held that the determination should be final and conclusive regarding the court which passes it. एक उन्होंने उसी इसमें एक केस था इन वेंकटा रेड्डी वर्सेस पेथी रेड्डी, AR 1963, I have not mentioned over here. Venkata Reddy versus Pethi Reddy, AR 1963, SC 992 case, the court observed that the crucial point which requires to be decided in such case is whether the decision is final and conclusive in essence and substance. If it is a decree. If not, it is not a decree. मतलब decree है या decree नहीं है. The court further held that whether or not an order of the court is a decree, the court should take into account pleadings of the parties and proceedings landing up to the passing of the order, with a view to find the meaning of the words in the order and to determine whether such order is a decree. The court often may have to consider the circumstances under which the order was made and the words were used. मतलब जो इसका सिंपल मीनिंग है जो हमने विद्याचरण शुक्ला केस में देखा है, अगर वो सेटिस्फाई करता है तो ही उसको हम लोग डिक्री बोलते हैं. वो अगर कैरेक्टर सेटिस्फाई करता है तो उसको हम लोग डिक्री बोलेंगे. There must be a formal expression of adjudication in simple terms to be declared. The court must formally express its decision in the manner provided by the law. मतलब जो expression भी होगा formal expression of decision, it should be in manner provided by the law. All the requirements of form must be complied with. The decree should be drawn separately and should follow the judgment. Decree के बाद में judgment आना जरूरी है. A mere comment of a judge cannot be a decree. Decree नहीं है तो appeal भी नहीं है. Judgment से नहीं होता है. No appeal lies against the judgment if the decree is not formally drawn upon the judgment. Clear किया है लोगों ने. In Shakuntala Devi Jain versus Kuntal Kumari, AR 1969 SC 575 page 577 case, the court held that decree should follow the judgment and should be drawn separately. और आगे उन्होंने मैंने explanation भी mention किया कि अगर no appeal lies against the judgment if the decree is not formally drawn upon the judgment. So we have seen there are actually 5 elements which are very important, and those elements are, एक तो first तो adjudication है, second suit है, इसमें parties के rights का determination होना चाहिए. Fourth point was it should be in conclusive nature, and the fifth it was the formal expression court का होना चाहिए. एक बार डिग्री निकल गई, फाइनल डिग्री निकल गई, इसके बाद में कोर्ट के हिसाब से वो पर्टिकुलर केस क्या हो गया, खत्म हो गया. डिसीजन कंसिडर्ड एज डिक्री, ये जो डिसीजंस है इनको डिक्री बोला गया है. order of abatement of the suit, dismissal or of appeal as a time bar, dismissal of suit or appeal due to requirement of evidence or proof, rejection of plaint due to non-payment of court fees, order granting cost and installments, an order refusing cost or installments, an order refusing maintainability of a fee, order denying the survival of right to sue, order stating that there is no cause of action, an order refusing to grant one of or several reliefs. एक इंपॉर्टेंट चीज आप लोग को देना है कि लिस्ट है, लेकिन ये एग्जॉस्टिव लिस्ट नहीं है। और जैसे जैसे हम लोग सीपीसी के आगे वाले सेक्शंस देखेंगे, ऑर्डर्स देखेंगे, रूल्स देखेंगे, तो आपको उसमें ध्यान में आएगा ये सब का डिस्कशन किया हुआ है। ओके, नाउ डिसीजंस व्हिच आर नॉट कंसीडर्ड एज अ डिग्री: dismissal of appeal for default, appointment of commissioner in order to take accounts, order for remand, order granting interim relief, an order refusing the grant of interim relief, rejection of plaint in order to present it to the proper court, application rejected for condonation of delay, order holding an application to be maintainable, order of refusal to set aside the sale, the order issuing directions for the assessment of miscellaneous profit. नाउ अगर हम लोग डेफिनेशन में जाएंगे डिक्री के, तो उसमें दो एक वर्ड था, सेक्शन 144 का एक मेंशन था और एक ऑर्डर रिजेक्टिंग प्लेंट का भी था। तो व्हाट इज डिटरमिनेशन ऑफ क्वेश्चन अंडर सेक्शन 144 ऑफ द कोड मींस an application for restitution can be filed under section 144 of the code. A restitution is an act of restoring a thing to its proper owner. When code passes an order of such restitution, then that order amounts to a degree. मतलब सेक्शन 144 में रेस्टिट्यूशन की बात की गई है, और रेस्टिट्यूशन का मतलब क्या, अगर किसी की चीज है उसके प्रॉपर ओनर को दी जाती है, तो उसका जो ऑर्डर निकलता है, ये ऑर्डर को हम लोग क्या बोलेंगे, डिक्री बोलेंगे। देन ऑर्डर रिजेक्टिंग अ प्लेंट, when a plaint is rejected, the order rejecting it is not an order but a decree and is as much appealable. It must be noted that there is no decree where the rejection of the plaint is not under the civil procedure code. अगर रिजेक्शन सिविल प्रोसीजर कोड के हिसाब से नहीं है तो डिक्री नहीं बोलेंगे। लेकिन अगर नाउ जब हम लोग डिक्री की बात करते हैं, उसके साथ में कुछ और भी टर्म्स यूज करते हैं, जैसे कि एब्सोल्यूट डिक्री, व्हेन डिक्री इज कंप्लीट itself and it becomes a full effect at once, it is called absolute decree. एक डिक्री निसी बोल के वर्ड आता है, the decree which is not to take effect unless the person affected by it fails to show cause against it within a specified time is called decree nici. And there is the ex parte decree, when the plaint is filed and the plaintiff appears in the court but the defendant does not. When the suit is called out, if it is proved that the summons were duly served on the defendant, the court may make an order that the suit shall be heard ex parte. In such case, the court may hear the plaintiffs only and pass a decree in manner. Such a decree is called ex parte decree.
Don't forget to subscribe to our channel for more videos, and press the bell icon to receive updates.